morning, President. Caribbean Court of Justice, Original Jurisdiction, hearing of the referral RFOG number 1 of 2026 between G. Anwar Barrow and 7 limited liability companies and the Financial Services Commission and the Attorney General of Belize. The members of this morning's panel are Mr. Justice Anderson, President and Presiding Judge.
Good morning, everyone.
Mr. Justice Jamadar.
Good morning to everyone.
Madam Justice Ononebu.
Good morning, everyone.
Mr. Justice Ibu Suji.
Good morning, all.
And Mr. Justice Balkan.
Good morning, everyone.
Counsel, may we please have the appearances? Thank you.
Your Honors, Godfrey Smith, Hector Guerra, and Edgar Lord appearing for the claimants.
May it please the court, Eamon Courtney, along with Priscilla Banner, Senior Counsel, and Stacey Castillo Isagiri, appearing for the first respondent.
Good morning, Your Honors. If it pleases you, Samantha Matut, along with Ms. Alia Gomez, and we represent the second respondent, the Attorney General.
Good morning, Your Honors. May it please the court, Carissa Rodolfo, alongside Mikhail Charles for the amicus.
Thank you all very much. I trust that you're hearing me clearly. Yes, great. Thank you. Thank you very much. I apologize for the technical problems that we are experiencing in the chambers. We are to hear this referral matter this morning. I think we have dealt with all of the procedural matters which are relevant. So we are now prepared to hear the attorney for the claimants. I believe that to be you, Mr. Smith?
Yes, Mr. President, thank you. Your Honors, of course, the claimants are relying on the written submissions, our responses to other sides. So my aim this morning is to flag up, if I may, the main points in support of the two issues that we are asked to address the court on. So first, of course, is jurisdiction. And our position is that the starting point for this court's analysis as to its jurisdiction is, of course, Article 214. Your Honors are all too familiar with what that requires, where a national court of a member state is seized of an issue whose resolution involves a question concerning the interpretation or application of the treaty. The court shall, if it considers it necessary, render a determination, deliver a judgment to refer the matter to the CCJ in its original jurisdiction. As the jurisprudence from this court has established, it's a mandatory, it must be referred once the judge has exercised his mind as to whether the requirements of 214 are met, and the discretion is limited as the jurisprudence further establishes. We say that a quick perusal of the fixed date claim, which is before this court, will reveal that at, I believe it's paragraphs 2G and 3D of the fixed date claim, that the issue of the interpretation of the Revised Treaty of Chaguaramas, Article 177(2)(d) squarely and frontally arises. It is therefore irrelevant. It is an issue that arises for the determination of the High Court. It is relevant to the factual matrix, to the background of the case. And so the requirements of 214, Article 214, are met. Again, the original jurisdiction rules lays out, I think it's 3 or 4 requirements in terms of the form, and the referral question scrupulously abides by and complies with the requirements of the form. And in this regard, I thought I should mention that I found the manual for referral of proceedings quite useful, because it's at paragraphs 3 to 5. It states plainly that the issue referred is for interpretive guidance, where an issue concerning the interpretation or application of the treaty arises. It's for interpretive guidance, and that is necessary to ensure that where a similar question or the same question arises in another jurisdiction, there is consistency and uniformity in the application of that rules throughout the community. So we say that on plain and ordinary reading of 214, the manual for referral, as well as the original jurisdiction rules, the referral meets those requirements.
Mr. Smith, just if I could just interrupt you, just to be maybe too technical, but still, when you read 214, what, if you had to deconstruct that, what would you say are the components that go to the question of jurisdiction?
All right, so on a deconstruction, we're a national court, the Belize High Court.
So you must have a national court.
And a member state, Belize is obviously a member state, is seized of an issue. That issue in this case, we say, is the relief claimed at paragraph 2G,
which concerns the interpretation of 177.
Correct.
And what about the rest of 214?
Right, and so it seized of the issue whose resolution involves a question concerning the interpretation or application of this treaty. We've been through that. The court, the Belize High Court, shall, if it considers...
Council and judges, the president, I think, fell off the space. So I was just told we are trying to get him back in. So can we pause?
Mr. Smith, I think you have to stop in mid-sentence.
There's a term for that. This is Jamara.
I hope it's a nice Latin term, Mr. Smith.
It might not be appropriate for litigation, Your Honor.
Council and judges, I was just given some directions by the president. If we could stand the matter down for a few minutes, please. So we will adjourn for a few minutes. Thank you so much, Justice Jamada and Council and all other council for accommodating us. Thank you so much.
he had gone to Article 214, and I'm afraid that's where I lost you. Would you mind resuming from that point, Mr. Smith?
Thank you, Mr. President. I had been asked by Justice Jamadar to demonstrate, to deconstruct 214 for the purposes of demonstrating that the referral, the court has jurisdiction or should exercise its jurisdiction. We had reached the point where we had gone past the national court, meaning the Belize High Court, if a member state being Belize seized of an issue. The issue is as stated in the fixed date claim, paragraphs 2G and 3D. It concerned the interpretation and application of Article 177. The court, the Belize High Court, shall, if it considers that the decision on the question is necessary to enable it to deliver judgment. Now, in this case, the consideration of the court or judge was aided by the fact that the application was made and acquiesced in, agreed to by ourselves as claimants. And on the basis of that, the court made the referral. We consider, however, that it was properly made since the question for the relief claimed in relation to Article 177 of the treaty is one of the several limbs in the fixed date claim. So there are constitutional challenges to the relevant sections of the Companies Act, which are listed in the fixed date claim.
Yeah, Mr. Smith, yeah, I think we've read the applications. Mr. Courtney's, I think, objection is on the point of necessity. So first of all, as a test, is the test of necessity subjective to the referring judge, or is that an objective standard that this court can review and say, the judge may have thought it was necessary, but we don't? That's one question. Hold on, pause. Then Mr. Courtney, I believe, says, well, look, it's not necessary because there's a constitutional challenge. And if that challenge proceeds, it takes priority because it's a constitutional challenge. If it proceeds and succeeds, well, that's the end of the matter because everything else goes. And so I think Mr. Courtney is saying, at this stage, I think that's what he's on. And if I'm wrong, Mr. Courtney, please interrupt and correct me. At this stage, it is not demonstrably necessary because of the constitutional issue.
Right. So on the first question, our response is that yes, this court, the CCJ, is able to look at it and say, well, we don't really think it's necessary and there is enough, it did not have to be referred. That is our position. On the second question, the true position is that, as I mentioned, there are several limbs to the challenge. It is possible, if the claim proceeds without the referral point, that other aspects, those sections may fall that are being challenged, but that ground will have remained unresolved. That is whether Article 177 reaches the claimant's rights under the Constitution of Belize. So it would remain an unresolved issue.
Mr. Smith, can I just take you back to your answer? This is Justice Anonu. Can I take you back to your answer to the first question posed by Justice Jamadar? I believe your response was that the CCJ, in its original jurisdiction, could review the question of whether this, let me call it loosely, necessity test was met. I wanted to explore that a little bit with you and ask you, is it for when the CCJ is determining whether it has jurisdiction under Article 214, is it in its original jurisdiction going to review the exercise of the discretion of the national court as it relates to the necessity of the guidance, interpretive guidance to delivering judgment, or is that something that could be challenged at the domestic level through an appeal?
Yes,
so I'm just, yeah.
Yes,
Thank
it
you.
could be challenged at the domestic level through an appeal. When the matter comes before the CCJ, it is not a matter of reviewing the discretion exercised by the High Court, but I believe the CCJ may be able to say, upon scrutiny of the relevant articles and rules, that they do not consider that it is necessary to dispose of the matter.
I'm exploring this issue because I found your submissions at paragraph 9, I think it is, of your reply interesting, because I took those submissions to be drawing a distinction on the one hand between review of the discretion, the exercise of discretion by the national court in determining whether a referral is necessary, or I should say whether it's necessary to have the interpretive guidance of the CCJ to deliver judgment on the one hand, and the considerations that you cited drawing on jurisprudence from the Court of Justice of the EU that were more appropriate for the CCJ to take into account in establishing whether it had jurisdiction. Considerations such as, I think you've referenced, whether this is a hypothetical or purely academic question, or if answering the question based on the facts and the background provided is in order. So I'm wondering if you could address that point, please. Thank you.
Right. Well, as stated in that paragraph, the position is that once the High Court has exercised made its consideration and made the referral under the mandatory terms of 2114 shall refer. We believe that has happened, that has occurred, and that enjoys, as we put in paragraph 9, a presumption of relevance. However, if it can be shown, or if the CCJ looks at it and considers that, look, the materials put in front of the court on the referral, or the relevance of the issue raised, it has no relevance, or it's entirely premature, then on those confined and limited bases, the jurisdiction could be declined. However, I need say nothing more than on the very face of the referral. Yes. It is clear that it is on the face of the referral. It is clear that there is a relevant issue connected to the
Mr. Smith,
yes.
I think we're okay with that. I think we just, because this is the first referral, there's some things we need to sort out, obviously. So do I hear you therefore agreeing that the CCJ in its original jurisdiction remains the guardian of its own jurisdiction then? In other words, are you saying that a local court cannot ascribe jurisdiction to the CCJ? They can refer on an assumption of jurisdiction. Yes, they should enjoy a presumption of relevance, but ultimately, this court is the guardian of its own jurisdiction.
I think it would be very difficult for me to go against that that argument. I think you have put it neatly. There is a presumption of relevance, and provided all the boxes are ticked, there should be the case where the CCJ declines, except on very clear matters. But yes, I believe that CCJ ultimately is the guardian of its own jurisdiction.
If I may join my colleagues, Mr. Smith, in indicating that we are indebted to your assistance in this matter because, as my brother just said, this is a new area for us, and we are very grateful for your help, and I'm sure we'll be as well for the others who speak. On this precise point, though, without descending into the details of this particular application, I think we wanted to remain at the more general level. One of the things I am concerned about on the face of it is that if the judge says, look, this matter is not necessary for the resolution of this case, it looks a bit awkward for the CCJ to then come and say, oh no, we think it's necessary, and therefore we're going to do X, Y, and Z, or the other way around. If the judge says, well, I think it's necessary to get an answer from the CCJ to resolve this dispute before us, as a little awkward, I think, for the CCJ to say, oh no, we don't think it's necessary. So I am wondering whether we could not approach this from a different angle. That angle being that the jurisdiction of the CCJ is decided at the first phase or phrase of 214. So the first comma that you arrive at, interpretation or application of this treaty, if the factors set out there are fulfilled, do they not suffice to give the court jurisdiction? So we must, as I think you were saying earlier, establish that national court or tribunal, and there's a lot of jurisprudence around that, as you probably know. Member state, that is also another area for discussion. And then seize up an issue involving a question concerning the interpretation application. That's another area for discussion, of course. The question is, if those conditions are met, why can't we say that the CCJ has jurisdiction? What follows, the court or tribunal shall, if it considers the question and so on, would that not go, or could that not go to the question of liability? That is to say that if the National Court or Tribunal does not refer when it considers that it should, and of course the discretion is that of the National Court, then the international liability of the state could be engaged. Now the question as to who could initiate that engagement is a different issue. We don't have to come to that. All I'm saying is, could we not look at it, and again, we were happy for your guidance and help, as suggesting that that first phrase in Article 214 is what decides if the court has jurisdiction.
Is the president finished on the point?
It's a question I was asking you, yes.
Oh, yes. Mr. President, yes, I agree. When you look at the rules, 10A2:10, the court will first determine whether it has jurisdiction under 214.
Yes.
Under 214. And under 214, the jurisdiction arises where it's clear on the face of the referral that a national high court of a member state is seized, that these are all objective.
Yes.
Is seized of an issue who's involving a question related to the interpretation or application of the treaty. Those are all objective factors. And therefore, when the court looks under the rules to whether it has jurisdiction, it looks to that.
Yes.
The other section then are subjective elements, and it would seem to me that the presumption has to be that on that second limb, if I can call it a second limb, that where the court has made the referral, then it enjoys a presumption of relevance. And that's where the case should stop. Now, I suppose I'm not a judge, but a careful judge would perhaps be careful not to make the rule so absolute as to say, in no case can the CCJ not decide to decline, even though on the face of it, it appears so. And that may go to Justice Jamadar's question that on broad jurisdictional, jurisprudential terms, of course, the CCJ is the guardian of its own jurisdiction. I don't know if that assists, Mr. President, but I would say that the first limb is objective. I termed it loosely the first limb, and that is clearly met on the face of the referral. The second limb tends to be more subjective and gets the apex court engaged in a consideration, which may appear a bit unseemly as to the considerations given by the High Court.
And the subjectivity,
there.
the subjectivity to which you referred is that of the national judge. If the national judge considers it necessary, so I'll be interested to find out, not necessarily now or from you, how it is that the CCJ is going to determine the necessity question. Because that seems to me, on the wording of the treaty, to be something in the purview of the national court or tribunal. But you could come back to this. I think you have provided us with significant assistance. Thank you, sir.
Thank you. No, it is a matter of catching my step. So I think perhaps I need not delay further on this point. The CCJ at the case management of this matter engage in a process of, shall we say, extracting or fine-tuning the question, which was a bit broad. So any question as to the referral issues having been too broad was adequately dealt with by this court. So I will pause there on the question of interpretation, on jurisdiction, unless members of the distinguished panel have any further questions on that before turning to interpretation.
I see no indication of further questions, so please.
Yes, on the substantive matter then of the question as framed is, given the question referred, how in the context of Chapter 8 of the Revised Treaty of Chaguaramas should Article 177 2D of the treaty be interpreted? We say this is our direct response. We say that analyzed through the interpretive lens of the preamble to the RTC and through the interpretive lens of Articles 7, 9, 169, and 170 of the treaty, Article 1772D should be interpreted as prohibiting regulatory measures or administrative arrangements that effectively apply unequal conditions to parties engaged or in equivalent undertakings in commercial transactions capable of resulting in a competitive disadvantage. That is a little bit wordy. Maybe I can try again by saying the position is, how should it be interpreted? It should be interpreted through the lens of the preamble and Articles 79, 169, and 170 as prohibiting regulatory measures or administrative arrangements that effectively go against what is set out or does what is prohibited in Article 177 2D. I pause there.
Mr. Smith, Mr. Smith,
Yes.
if I may come in, it's entirely appropriate in my view for you to look at the treaty in the round. You've taken us to the preamble, perhaps preamble of paragraph 7, I imagine. You've also taken us to Article 79, 169, and 170. How about Article 30, sub 2? Can we also look at it from that perspective? Article 30, sub 2, of paragraph 2.
1 second. I did not address that. I mind to 30 sub 2, but I'm going to pull it up right now.
Yes, I know it does point to this chapter, if I may read it. It says,
Yes,
activities, if I may read it for the record, activities in a member state involving the exercise of governmental authority shall, insofar as that member state is concerned, be excluded from the operation of this chapter. Yes, I know it does say from the operation of this chapter, but does it give us an indication about how to look at Article 177, given in particular that distinction that we know in the law between, to use the Latin expression, iure gestionis, meaning commercial activities, even of government, versus iure imperi, which is what's being addressed in Article 30 sub 2, meaning administrative acts of governance. Does 32 help in seeing what 177 is trying to say?
Well, what 177 has to be read in the context of Chapter 8 and the broader treaty. 177, Justice Ibo Suji, is, we could perhaps term as the competition rules.
Yes.
But the competition rules are not standalone. They don't exist solely for the purposes of enforcing of the rules. They exist to give effect to the 5 freedoms enjoyed under the RTC.
And those 5 freedoms, those five freedoms, we begin to get the matching order, so to speak, from Article 30. Is that correct?
Well, Article 30 certainly sheds some light on it, but my response to that would be that if the matter should be approached from an outcomes perspective, if the outcome of a regulatory measure or administrative arrangement is, if the outcome is exactly that which the competition rules attempt to prohibit, it clearly cannot, it would affect the effectiveness of the competition rules. It would diminish the efficacy of the competition rules.
Yes, you began by saying that the essence of the matter is on the concept or notion of competition. And then we understand competition to be essentially a contest amongst rivals, isn't it? And when you're looking at Article 30, paragraph 2, from that perspective, when we have a government doing regulation, and then we turn to Article 177, seeing that Article 177 speaks about anti-competition measures, anti-competition business practices or business conduct, and we look at what has been pointed out in that provision, does it not tell us that Article 177 is dealing with a contest amongst rivals, supposed to regulatory activity of state?
Okay, so our response to that is, yes, the first purpose of 177 as competition rules is directed at the players, the actors, the private sector, the private enterprises. That is true. That is its first object. However, the purpose of the competition rules is to ensure that there is no distortion of market conditions, to ensure that competition reigns. And therefore, you have to look at the broader requirements, especially of the general undertaking on obligation at Article 9, which requires you not to do things that would take away or diminish or frustrate the objectives of the CSME. I want to perhaps remind the court of, well, I shouldn't say remind because this is overfamiliar to you, but 175 of the RTC requires that within 24 hours of the coming into force of the treaty obligations, that member states shall notify quoted of what? Of all legislation, of all decisions, of all administrative arrangements that go against or are inconsistent with the provisions of Chapter 8, which deals with competition. It goes further. It says that within 36 months, quoted shall then come up with a plan of action for the repeal of legislation, decisions, and administrative arrangements that are inconsistent. It can't be then that many years after that, the state introduces legislation that allows, through administrative arrangements, a distortion exactly in the effect that is prohibited by 177.
Mr. Smith, just to come in quickly.
Yes.
What I found interesting about your submissions is that you, I think, very clearly formed the view that the treaty can discipline measures of the state which distort competition between actors in the marketplace. Yes. I certainly don't disagree with that proposition, but I think what is the focus of our attention is whether the provisions that are the focus of this referral actually do that, or actually are the provisions in the treaty which do that. So I'm taking a step back and I'm saying I agree that there are disciplines in the treaty. There are provisions in the treaty that can discipline regulatory measures which have the effect of distorting competition, which have the effect of placing restrictions or impairing the exercise of certain freedoms. But the question before us really is quite specific. It really is asking the court to interpret what is really the target, the focus, what is disciplined or prohibited by Article 177 2D. So I come back to a basic question. Can you, and I'm later going to make a reference to Article 7 and 9, which you refer to, but my very specific question to you is, what is the behavior which is prohibited by Article 177?
It is behavior that results in anti-competitive disadvantage, or which distorts the market, the competitive market. It is behavior. But
Mr. Smith, just to interrupt a bit in that context, behavior by whom?
Well, yes, the behavior is by enterprises, and enterprises have been jurisprudentially established be usually private sector actors, but as the European jurisprudence has evolved, it has caught in that net public sector departments and bodies. So it also includes, you asked by whom, behavior by whom, on a strict and technical reading, it is by enterprises engaged in the marketplace. However, we are inviting the court to look, the primary focus is on actors. We suggest that the secondary implied approach, implied thing in 177 2D is the outcomes. Actors versus outcomes. Yeah. What is more important is, to our mind, is the outcome, regardless of who is doing it, whether it's private enterprises, whether it's a parastatal body, whether it's a fully governmental authority, whether it's legislation, if the effect of it is to diminish the rules, then 177 2D is equally capable of being understood as prohibiting such administrative arrangements.
Very well. I think we will have to bear in mind the time. We have exploded the order as regards time a long time ago. But to maintain some semblance of discipline, let us say another 20 minutes. And I think that Justice Ananiwu was asking you a series of questions. She started with her first. Perhaps you want to continue, Judge?
Thank you, President. And to maintain the focus on what is targeted by Article 177, I note, Mr. Smith, you keep using terms like anti-competition, anti-competitive effect, but you keep omitting a very important word that appears, which is business. In other words, the conduct that is the target of Article 177. Yes, it's conduct which has anti-competitive effects in the marketplace, but it's conduct undertaken by business. And I'm trying to understand your argument in light of how certain terms, so I'm not going to EU jurisprudence, I'm looking really squarely at the treaty. And Article 1 defines certain terms. It defines the term business, it defines the term enterprise. And yes, I agree, an enterprise could be, it doesn't have to be a non-state actor, but it has to, for the purposes of Article 177, be engaged in business, no? As defined in the treaty?
The simple answer is yes. And I have conceded, Justice Onaniwu, that is the primary focus. I am inviting the court to construe that there is a secondary implied target of 177, and that has to be secondary, and it has to be implied from the very compelling provisions of 169 and 170 and 9. You have to read them together.
If my sister doesn't mind, I wanted to coming on our line of interrogation. To ask you, Mr. Smith, how would you link your argument now, i.e., that we can look beyond 177 2D to the case that you have before the High Court of Belize? Because it seems to me that that's where we started, that the resolution of the issue that is before us must be necessary to the judge's resolution of the matter before the High Court. Now, if in the High Court you have not cited the articles to which you are referring, you have not cited Article 7, for example, you have not cited Part 3, etc., how could you make the case that our passing on those articles and the interpretation of them would be necessary for the judge in the High Court to resolve the dispute before that court?
If I understand the question, the fact that the other articles and the preamble are not pleaded in the fixed date claim with respect is immaterial when a court in its constitutional jurisdiction sits to determine a detailed right under a constitutional provision. Nothing stops it from looking at the preamble, from looking at the chapeau to the detailed rights, which includes the general declaratory statement of those rights, and treating the preamble and that chapeau as sort of a interpretive foundational clause that guides how the detailed provisions are to be interpreted. It goes hand in hand. It's not divisible. So the answer is if the court below or this court is asked for the interpretation of 177 2D, it is a natural, organic part of the process of determining the issue, to look at the treaty as a whole, to look at the objects and purposes as set out in the preamble, and to look at the broader policy objectives of the competition rules that are stated at 169 and at 170. That's how I would answer that, Justice, Mr. President.
Yeah, thank you, sir. My sister, sorry.
But if I may pick up from that, Mr. Smith, so you would say then, in this particular jurisdiction under Article 214, this court would have the same wide-ranging exploratory power that a domestic court in its constitutional jurisdiction would have, because I agree, if you are interpreting the Constitution, you're certainly not confined to the section, and you can go beyond. But in this very narrow, well, what I would have thought, very narrow jurisdiction under 214, when you're interpreting a section of the treaty, does this court have the same sort of exploratory, wide-ranging ambit?
Well, with respect, Justice Bulkin, I'm not sure I would agree with the term exploratory, because exploratory suggests a degree of adventurism. And I think it is well beyond that. I would say, in direct answer to your question, that yes, it's a narrow question of the interpretation. But once you embark on the process of interpretation, it cannot be straitjacketed. It has to be in the normal course, whether you have the full dispute before you as a CCJ, the full dispute referred by a member state, or whether the High Court has asked for an interpretation of 177, you absolutely must exercise that jurisdiction in its fullness. Otherwise, you will end up with an improper interpretation.
But sorry, at the same time, you would concede that the request is for the interpretation of 177. The request is not for the
Yes.
interpretation of, say, Article 7, right?
Yes, but this
Very
is
well.
an apex. This is an apex court,
Thank
Mr.
you.
President,
Yes.
and an apex court is obliged to not compartmentalize or bifurcate its jurisprudence. It's asked to give interpretive guidance as to what 177
Yes.
2D means, and inextricably. I think I've made the
Yes,
point.
I think you have made a point. Yes. Justice Ononewu,
Mr.
were you
Smith,
finished? Yes.
thank you, President. Thank you. And just a quick note, I know you've been referring to us as an apex court, which we are, but right now we're exercising our jurisdiction as an international tribunal.
Right.
So,
but at the highest level, there is
Touché.
no higher than this.
Noted, Mr. Smith. Now, Mr. Smith, I wanted to return to the interpretation of Article 177. I do appreciate that you're inviting the court, if I could characterize it as such, to undertake a purposive interpretation of the provision that's guided by the preamble, various statements of objectives in the treaty. I note that you have cited both Article 7 and 9, and the question I'm about to ask is not aimed at providing an interpretation of those provisions. But I found it interesting in your submissions that you are citing certain jurisprudence of the Court of Justice that acknowledged that the parallel provisions in the EU treaties, yes, they apply to undertakings, but when read in conjunction with the equivalent of Article 9 of the Revised Treaty, could be interpreted as prescribing legislative measures that undermine, if I would say, the effectiveness of the competition rules.
Yes.
But you see, what I'm putting to you for consideration, and I'd love to get your response, Mr. Smith, is that even that jurisprudence that you're citing, what they're targeting are measures that undermine the effectiveness of competition rules that prescribe anti-competitive business conduct. That jurisprudence isn't redirecting what the focus of the competition rules actually is. So they acknowledge that the focus of the competition rules is, really ensuring that undertakings don't engage or enterprises don't engage in anti-competitive business conduct. And then if there is any anchor or cross-reference to Article 9, which you're citing in this case, it's really to ensure that the state doesn't undermine the effectiveness of those competition rules through the way it regulates. But coming right back to Article 177, I'm not clear how even a reference to Article 9 changes what the primary focus of Article 177 is, which is prohibiting anti-competitive business conduct. So I'd really like to hear your thoughts on what I've just said. Thank you.
Thank you, Justice Ononewu. I have already conceded what primary focus is. I also accept the point that the various European authorities cited are not on all fours, as we say, with the facts of the case at bar. We rely on them to show, well, obviously, that state measures can be subject to review under Article 9 of our treaty, as well as, I don't think we should forget about 170 subsection 5 and what that means. I want to say this, that obviously in one of the CCJ cases, was it Trinidad Cement? There was a statement in there that the private sector or private enterprise are the engines that they drive the single market and economy.
I think that's reflecting the preambular statement to that effect.
Yes.
Yes.
However, all that is predicated on the state providing an enabling environment, removing administrative practices, legislation, and decisions. Note, Justice Ononewu, if we look at 170, while I agree that the strict confined rules at 177 speak of decisions, agreements, and practices of enterprises. But there is a reason why at 175, when the commencement of this regime was contemplated, 170 at subsection 5, implementation of the competition policy, there is a reason why member states were required to identify not only decisions and agreements listed in 177, but legislation and administrative arrangements. And there is a program to remove and repeal those that are inconsistent. Keyword underline, inconsistent with the chapter. Now, there seems to have been a presumption that states will act properly and in accordance with that. And once all those have been repealed, then the competition rules are free to engage without reference to statal bodies. But what happens when the very thing sought to be prohibited under 175 is reintroduced in 2022 through the Companies Act that has the effect of diminishing the competition rules? We say surely the court ought to interpret it ought to interpret 177 to mean interpret 177 read with the other relevant provisions of the treaty to mean that where the outcomes result in a competitive disadvantage, it is also prohibited.
Yes.
That is, I think, the best argument I can marshal in response to Justice Ononewu's question.
Yes, thank you very much. Are there other points you wish to marshal?
I think at this point, no, I think I'll pause there and ask their questions. And in the I don't think I've used up the 15 minutes that's that's reserved for reply.
Yes.
So I will try to hold that in reserve for.
You may, sir. We'll make a note of that. Thank you.
Thank you.
Thank you very much, Mr. Smith. First respondent.
May it please the court. I want to start by referring to agriculture. Having listened to my learned friend, Mr. President and your honors, a mango tree cannot produce a banana. Why do I say that?
I am not sure about the biotechnology of that, you know. There's a sweet spot there, and we could and maybe should explore that outside of these more forensic proceedings. What do you think, Mr. Courtney?
I look forward to exploring it, Mr. President.
So do we. Thank you, sir.
My point is simply this. You cannot, on a referral, say to the court, in the main proceedings, I have pled and relied on Article 177. I have asked the High Court to refer a question relating to 177 to the original jurisdiction of the CCJ, and then come to the CCJ and say, you know something? I would like you all to refer to other articles and answer the question by reference and reliance on other articles which were not pleaded in the court below, which the court below has not asked you to consider, and which the court below has not said is necessary for it to give its judgment. Mr. President, Your Honors, we start by saying there is a specific and very focused question that has been pleaded below, that has been referred.
Well, I'm happy.
I think we've lost Mr. Courtney, haven't we?
I think he might be back, brother. And I'm very happy I'm not the only one with technical problems. Mr. Courtney, are you with us, sir?
Can you all hear me just to make sure
We
it's not a
can.
Belize problem?
No,
Okay.
it's
My
not a
screen has
Belize
gone
problem.
completely blank.
You're back, sort of. There might be a bandwidth problem, Mr. Courtney. Would you mind turning off your camera?
I am
and see
back,
if
you
that
said.
would- Do you want to try without the camera and see if that would help?
Mr. President, can you hear me?
Yes, but you are very disjointed and it's not coming through smoothly. We're suggesting you turn off the camera and see if that would help. It's a deprivation for us as well, but we have to do what we have to do.
On that note, President, I wonder if I am having the same problem. I got a sign that that I appeared frozen at some point. I don't know whether that's the case.
Brother, you were frozen earlier, but we were very happy that you were still with us. We could hear you, but you were frozen on the
Yes,
screen.
I did not want to flag it because I was hearing everything smoothly, so I did
Yes.
not want to make an issue then to delay proceedings.
Appreciate it.
Yes.
President,
Yes, ma'am.
Mr. Justice Ebo, Suji.
Am I still? Do I have that problem?
You are
still?
perfect as usual, my brother. You're fine.
Oh, thank you. Let's keep saying that. Thank you.
Mr. Courtney?
It looks as if he's off.
You're back with us.
My profuse apologies,
Yes.
Your Honors. Your Honors, I would like to start by saying that I propose to make my submissions in 3 parts. Very brief submissions on the jurisdiction of the referring court, the High Court of Belize, to then turn to the jurisdiction of this court, and finally to deal with the merits of the matter that is before the court. And I will respond to some of the questions posed by the court to my learned friend in the process of my submissions. Your Honors, it is for the High Court of Belize, pursuant to Section 96, subsection 3 of the Constitution of Belize, to make a referral. I disagree with my learned friend when he says to this court that the language of Article 214 and the language of Section 96.3 of the Constitution of Belize provides a mandatory obligation on the court to make a referral. It is my respectful submission that the language is such that the court exercises a discretion described in paragraph 26 of Hummingbird Rice Mills as a limited discretion. The word shall appearing in Article 214, which also appears in the Constitution, is followed by the phrase, and the critical phrase, if, start that conditional, if I may read it, if it considers that a decision on the question is necessary to enable it to deliver judgment. So it has got to make that analysis, reach a determination as to whether or not it is necessary. And if it is necessary, then it can decide to refer it. There are cases which show that a court, a referring court, can exercise that jurisdiction, but the referred court, or should I say the court, the original jurisdiction court, in our case, the CCJ, may decline to exercise its jurisdiction. So, Your Honor, the last point I wish to make on the decision of the High Court of Belize is it is not open to the Caribbean Court of Justice to review that decision. That is a domestic law decision. It is open to appeal in the normal way through the domestic hierarchy of courts. That having been said, the matter comes to the CCJ, and the rules, Rule 10A, specifically asks this court to determine whether it has jurisdiction to entertain the reference. Your Honors, I now turn to the second part of my submission, which is the jurisdiction of this court. The position is very simple in my respectful submission. This court is duty-bound to ask itself whether or not it has jurisdiction to entertain the reference. I pose a hypothetical. If this claim was filed in the High Court in Belize, and before the first or second respondent does anything, the High Court judge to whom the case is assigned looks at it and says, wow, this case raises a revised treaty issue. I need to refer it, and refers it to this court. Is it that this court simply says, it has been referred to me by a court in Belize, there is an RTC issue, and therefore I am in duty bound to consider it and to rule on the merits of the question raised? The answer in my respectful submission is no. And the answer is no, because the test for this court's exercise of its jurisdiction is necessity.
Sorry, where do you see that?
I would read, Your Honor, Article 214 says, and then I go to the rules. Article 214 says, where a national court or tribunal of a member state is seized of an issue whose resolution involves a question concerning the interpretation of this or application of this treaty, the court or tribunal concerned shall, if it considers that a decision.
Yes. Yeah. So underline the word
court.
It. Yes.
Yeah. If the Belize court.
Yes. Yes.
Yeah. If the Belize court considers that a decision on the question is necessary to enable it to deliver judgment, refer the question to the court for determination before delivering judgment. When you go to the rules,
which of course cannot override the treaty.
But Your Honor, that is why I started with the submission
Yes,
that this court is not to review the decision of the Belize court.
right.
My submission is that when it comes to you, under your rules, 10A2 says, 1, where a national court is seized of an issue whose resolution involves a question concerning interpretation or application of a treaty, the court concerned shall, if it considers that a decision on the question is necessary to enable it to deliver a judgment, refer the question to the court for determination before delivering judgment. You then go to 10. The court, meaning the CCJ now, will first determine whether it has jurisdiction under Article 214 of the treaty to answer the question referred. Where the court determines that it does not have such jurisdiction, the reasons for this determination shall be given in writing and sent by the registrar to the appropriate officer, and those served pursuant to Subrule 5. That provision, in my respectful submission, confers upon this court an obligation to consider, first of all, whether or not it has jurisdiction. It has to look at what has been sent to it and to determine whether the treaty, whether the articles, and whether the rules have been engaged. For completeness, Rule 11 says, 10A211 says, where the court determines that it does have jurisdiction, it shall proceed to answer the question referred. Those two sub-rules, in my respectful submission, is sufficient to put the court in the position to inquire whether it has jurisdiction. We have
Mr.
set
Courtney,
up-
if I may come here, is it possible that a question of jurisdiction of there may be instances, of course, where the CCJ may decide that it may not have jurisdiction. And maybe that, maybe we're looking at the preliminary provisions in Article 214. But does the question of the CCJ's jurisdiction, is it determined within the phrase, if it, meaning the lower court, if that court considers that a question, a decision on the question is necessary to enable it to deliver judgment, is that what decides the jurisdiction of the court, or is that conclusive, rather, that the CCJ has jurisdiction if what the preliminary parts of 214 have been met? But then the court sees of the question says, look, I have a job here to do. The job is to render a judgment on this case before me. And I see in this case a question. At the end of the day, I will be interpreting the RTC. But before I can do that, I want to ask the CCJ, because I see that this is how this case is going, where it is going. So I'm asking the CCJ this question. Once a judge has made that determination, it has made that determination about how it sees the case before it in the direction it is going, isn't that conclusive of the jurisdiction of the CCJ to determine, to entertain the question, as opposed to deciding it one way or the other? Jurisdiction to entertain the question posed to it. Isn't that a way to look at this?
Your Honor, the last part of your question is what I would like to focus on. It is my respectful submission that the CCJ is obliged to use the words of Mr. Justice Jamadar to be the guardian of its own jurisdiction. It is my respectful submission that the High Court of Belize cannot determine whether or not the CCJ will exercise the powers granted to it under 10A2, 10, or 11 and preclude it from inquiring into the matter before it. The analogy which I would like to offer, and I merely say it as an analogy, is the competence principle in arbitration. I do not deny, and this comes to the last part of your question, Judge, I do not deny that the CCJ is the forum. The CCJ is the exclusive place with jurisdiction to entertain a referral question. That's accepted. That having been done, it is our respectful submission that, as the rules say, the CCJ must itself inquire and ask itself whether or not it is going to exercise its jurisdiction.
Those are two different things, though.
Yes.
Right in there, I think you hit it on the head, whether the CCJ will exercise the jurisdiction. So there's a difference between not having any jurisdiction to begin with versus I have that jurisdiction, but I've decided for XYZ reason that it is not appropriate to exercise it on this occasion. Isn't that about it?
Your Honor, I accept the phraseology, and I will say it is no different from the Supreme Court of Belize saying, I have original and unlimited jurisdiction to entertain civil and criminal matters. The fact that I file a claim form in the Supreme Court, the High Court of Belize, does not mean that the court has jurisdiction over that matter. The court itself has to determine, yes, you have filed it in my court. Yes, I have powers. I now have to determine whether the rules of the High Court are complied with to determine whether you have, whether I have jurisdiction over the matter. And I submit to this court that the question that arises in this case is for the court to make a determination as to whether it will exercise jurisdiction. And I say exercise jurisdiction in the second sense. The first sense, this is the only place that the matter can be referred to, and it is the only place that can determine whether.
Mr. Courtney, I think we have you on that. I think the nub of this aspect is whether the what has been referred to earlier, the subjective requirement of necessity versus of three objective criteria. And I think what is on the table for discussion is whether jurisdiction, whether you say how exercise, let's not get too caught up in that for now. Is that determined by the quote unquote three objective criteria solely, or is it in terms of the entire provision of Article 214, which includes that box ticking exercise plus what has been called the subjective criteria, that is to say, the local jurisdiction judges discretionary choice that it is necessary to enable it to deliver judgment. Where are you on that one?
Obliged, Your Honor. Could I invite the court to turn to my written submissions, page 839 of the record? We have set out there in paragraph 8 a 5-limb test, which we ask this court, we urge this court to apply to determine whether or not it will exercise jurisdiction. It's on page 839 at paragraph 8.
Yes, we saw that.
Okay, thank you.
Yes, and again, you know, in relation to this point, we want to thank you, as we did your colleague earlier, for the assistance you render here, because this is very important for us, obviously, going forward, and we appreciate very much the help that you have given. I'm still troubled by, for example, D. Determine whether the advice being sought by the referring court is necessary for it to deliver judgment. And the practical problems I alluded to earlier, I think, arise again. Are we in a position to decide if the interpretation is necessary, or is it a discretion in the hands of the local judge? Because if a local judge says, I think that this is necessary, and I can't answer the question before me unless I have some help, how are we to say to that local judge, no, it's not necessary for you to get this answer? So is this not something in the bosom of the local judge and not resident here at the CCJ?
Your Honor, I can give you an example again to make good my point. If this case was filed and before the respondents do anything, the High Court judge looks at the pleadings and says, an RTC issue has been raised, I am referring it to the CCJ.
Yes.
On the analysis that I am hearing, the CCJ is required by the treaty and by the treaty and the rules to determine that question in order that the judge can give judgment.
No, sorry, with respect, Mr. Courtney, I think what we are saying or what we are proposing is that, first of all, the CCJ would have to satisfy itself that the objective criteria to which Justice Jamadar referred gives the CCJ jurisdiction. So a court below cannot impose jurisdiction on the CCJ. The CCJ would have to be satisfied that these objective criteria are fulfilled. And then we come to Justice Ibo Osuji's point that you are now in a position where the CCJ has jurisdiction, but it might decide not to exercise the jurisdiction in a particular case. I mean, the doctrine of forum convenience is based on a court having jurisdiction in the precise case, not in a general sense, over the subject matter and over the parties, and yet deciding that it's not going to exercise that jurisdiction for all kinds of different reasons. And we're wondering whether this is not a logical way of interpreting 214. That the first phase gives the court jurisdiction, and what comes afterwards can amount to factors which would influence the exercise of that jurisdiction by the CCJ.
Mr. President, I wish to be clear. The Caribbean Court of Justice, in exercise of its original jurisdiction, has jurisdiction simpliciter. That is to say, if a high court in Belize refers a matter regarding the RTC, the only place it can refer it to is the CCJ. That is jurisdiction. The matter is before you. That is my respectful, sir.
That is jurisdiction in the original jurisdiction.
Yes.
But in relation to jurisdiction in this particular case, then the criteria which my brother mentioned, Justice Jamadar 214, the court would have to satisfy itself that these criteria are satisfied in order for it to have jurisdiction. So the court would have to satisfy itself, for example, that the question is coming from a national court or tribunal. And that's not an easy question, actually. A member state, of the member state. So there's another question. Then the third question is that this is an issue whose resolution involves the interpretation or application of the treaty. So the CCJ, not just in the sort of generic umbrella sense, would have to satisfy itself that these conditions are met in relation to the particular question referred to satisfy itself it has jurisdiction. And it's only at that point that the question comes in that my brother was raising, Ebo Suji, as to whether it might be appropriate in a particular case to exercise that jurisdiction or not. And I'm just wondering whether you think that that is a feasible way to read the provision.
Your Honor, that is a feasible way to read the provision. I was seeking to assist the court on answering that second part, as I said to Justice Iwo Suji. It is the second part of his question to me that I thought the court would have wanted some assistance on, and that is where I respectfully submit the question of necessity comes up. Is it that this court is going to be issuing opinions, advice on hypotheticals, on academic issues, on issues that the court below says is necessary. And on the papers that I've sent to you, you can see quite clearly that it is not necessary for the court to give judgment.
Mr. Courtney, can I
Courtney,
just
that's actually
ask
the
you?
point, not the point. The point being that it may be that the court has said, look, this is a matter on which the court has jurisdiction, but the court, meaning the CCJ, decides on this particular occasion, we will not exercise jurisdiction because it seems to us academic, it seems to us that the matter hasn't resolved, or for whatever reason, the court considers that, look, yes, we have jurisdiction, but it would not be appropriate for a court of law to exercise jurisdiction on this particular occasion. I think it's the same thing.
Can I just ask your clarification on one little thing? Because necessity in 214, is that a question of law to be determined on the pleaded facts? In other words, is this something that is peculiarly in the bosom of the local judge, or is it discoverable and ascertainable from the record by this court? Because maybe let me leave it like that for now. In other words, if you have to discover what is the evidence, and by evidence, I don't mean testimony, I mean, what is the material that is before the local court when it decides necessity to refer?
Your Honor, I'm grateful for the question because it brings sharply into focus what I have been trying to say. I asked the court, and I don't need to turn it up right now, in answer to this question, to look at the DCP successors case in Jamaica, not the one that Your Honor's decided. It's in the bundle, and what that case shows, the inquiry by the trial judge, in that case, as to whether or not the matter should be referred. And he did not refer it because, looking at the papers, he said, I am not at the stage yet to know whether I need to know the answer to that question to deliver judgment. So he didn't refer it. I asked the court to take a look at the London steamship owner's case. That is a clear case where it was referred to the ECJ, and the ECJ, it was referred, and the Court of Appeal said it should not have been referred because there is a human rights issue, in our case, a constitutional law issue, which can be dispositive, and therefore there is no necessity for the court to, the European Court to pass on the European law question. You are not yet, it is not necessary for you to deliver judgment. So, Your Honor, back specifically to Mr. Justice Jamadar's question, that is why in our respectful submission, we set out in paragraph 8, our 5-tier test, which we urge on this court to look at the papers that are filed in the court, look at the question that has been asked, ensure that the treaty article has in fact been engaged. And we say, go on to the question of necessity, as we set out in number 4, and whether or not the court, the Belize High Court, is really at a stage where it needs my advice, i.e. the CCJ, for it to deliver judgment. And so the answer very specifically, Mr. Justice Jamadar, Your Honors, is the court is to look at all the papers. And in fact, that is why the rules give this court the power which this court exercised to say, we have your application, but send me additional papers. I want to get the full picture for the specific purpose of seeing what is at play below, from seeing what is the question as it is defined, and from seeing whether or not it is necessary for the court to pass the advice to the High Court for it to deliver judgment. So again, I repeat myself, our submission is the 5-prong test set out in paragraph 8 of our submissions.
Thank you very much.
Mr. Courtney, Mr. President, one question
Yes.
from Mr. Courtney. Do I hear you Or do I sense that in all of that, and I ask this question because we are now at the inceptual stages of this kind of jurisdiction, original jurisdiction, but do I hear you in that suggesting that it may be the case that a referral may be subject to an appeal at the lower levels? In other words, somebody in your position might say, well, the referral question should not have been done. Therefore, it will be appealed to the Court of Appeal to determine whether or not he should come to the CCJ. I don't know. I'm just asking this question, whether you think that may be a scope for that in the exercise of the referral jurisdiction.
Your Honor, as I submitted a short while ago, the decision of the High Court judge is appealable, and it is to be determined within the framework of the domestic court's jurisdiction. You have repeatedly raised the question of the discretion of the CCJ once the referral is before it and once it has satisfied that it has jurisdiction simpliciter. It has occurred to me that one option that is always open to this court in exercise of its jurisdiction is to stay the proceedings before it and to say, it does not appear to me yet that my advice is necessary in the court below. So that rather than
the party in the proceedings will need to inspire that stay. The CCJ just can't, I'm looking at it, say, well, there is no appeal. Why does the CCJ need to stay? Is that something that the party in the case would inspire by appealing the referral and then leaving the CCJ with that discretion to stay pending the resolution of the appeal?
Well, I don't know that an appeal is the only way to trigger that. I think one way to trigger it is like where we are today. The court can be looking at this, counsel can be looking at this, and the question can be raised. Is this really right for my determination, counsel? Counsel, I want to hear you on that. And the court may exercise its discretion in that regard. To be clear, I am not asking the court to stay this matter. Our very firm submission is that the court should decline to exercise jurisdiction in this particular case because of the stage at which the High Court proceedings in Belize has reached, and it is not necessary for this court to give its advice in order for the court in Belize to deliver its judgment.
Okay, I think we have you there. You're going to move on to the merits.
Just about to say,
yes.
Yes, I was just about to say that, of course, we rely on our written submissions and the authorities which we pray in aid, Eli Lilly and Central Grouper, etc., in support of those submissions. Yes. Your Honors, if I can turn then to the final part of my submission and start by seeking the court's indulgence and apologizing. I sent a case yesterday afternoon to my learned friends and to the registry, but I did not file it simply because I didn't have permission. It's a case, and again, it's a case from Employment Appeal Tribunal, and so I apologize. I want to refer to it for 2 paragraphs only. I suspect your Honors don't have it before you, but my learned friends have them, and I ask the court to grant me the indulgence to refer to that case.
Any problems, Mr. Smith?
Sorry, Your Honor.
Any
Mr.
difficulty
President?
with Mr. Courtney referring to this case which you have?
No.
Okay, Ms. Matute?
No objections, Your Honor.
Yeah, please, Mr. Courtney.
Deeply indebted. Your Honors, this case, one of the reasons why I referred to the case is because it does quite an extensive review of quite a number of the authorities that may be helpful to the court. I won't go through them. I just want to refer to it for two paragraphs, which is paragraph 47 and paragraph 52. Paragraph 47 says, the definition of economic activity is settled. It can be traced back to the Commission of European Communities against Italy, if not earlier. It was reaffirmed in the present context by the Court of Justice as, and subsequent cases as, any activity consisting in offering goods and services on a given market is an economic activity, end of quote. And we say that that is settled, and it's also buttressed by the definition that appears in the treaty. Paragraph 52 says, as to whether a transferred activity is not an economic activity, but one to which regulations 3.5 of the TOOP regulations applies, the cases have, as I have highlighted in the annex, used many expressions, and this is what we pray in aid. However, the central concept remains that expressed by the Court of Justice in the Commission of the European Communities and Italy, what it called, quote, exercising public powers, unquote, is not an economic activity. Your Honors, there was quite an exchange with my learned friend and the bench about the focus of Article 177, and I will take this opportunity to repeat. The question referred to this court is on Article 177. The fact that a case can be made out under another article has not been referred to this court. The focus of Article 177 is pellucid. It is directed at economic activity, and it seeks to prohibit anti-competitive business conduct. Your Honors, with the greatest of respect, what is before you simply does not fall within Chapter 8 of the treaty, and simply does not fall within Article 177 or any of the articles in this section. The factual matrix is that the first respondent is not involved in any economic activity. It is not offering any goods. It is not offering any services in any market. It is not an enterprise as defined in the treaty, and it is not conducting business as defined in the treaty. And Your Honors, I ask the court to step back to the question of Mr. Justice Jamadar, and to review the papers below. What is being challenged? It is a constitutional challenge to provisions of the Companies Act. I pause there because on any analysis, that cannot constitute any activity. There is no complaint that the FSC, the Financial Services Commission, is doing something in the market. It is buying or selling or doing anything. The claimants wish to conduct business in Belize. They apply, and the law says, get a registered agent, pay in US dollars, and it does that. That's what the law says, and that law is being challenged. There is no activity, economic or otherwise, conducted by the FSC. And Your Honors, we submit that notwithstanding the fact that it is possible for a parastatal, for a public body to be in the business or carrying on economic activity, the factual matrix before you demonstrate that there is no economic activity carried on by the Financial Services Commission. I go one step further. If it is that the court regards the FSC on the facts of this case as an enterprise within the meaning of the treaty, we respectfully submit that the sections challenge, the most that the FSC could be doing is exercising public power, public authority. And that is not economic activity. Finally, Your Honor.
But Mr. Smith's argument boils down to saying, well, not boils down, he actually articulated it. He says, well, it's all well and good to say enterprises should not engage in anti-competition behavior, but here you have a state effectively enabling that by its own regulations and rules and laws.
I heard
That's
him.
the point, and how do we deal with that?
He has challenged those provisions in the domestic court on the basis that his client's right not to be discriminated against, etc., are being violated. And it is for the domestic court to answer that question. What my learned friend is seeking to do very eloquently is to ask this court to turn upside down all the understanding of Chapter 8 and to focus Chapter 8 on a law and to focus Chapter 8 away from economic activity.
Mr. Courtney, on that point.
I think we've lost Mr. Courtney.
Yes, we have.
Maybe, President, this may be a time for a short break.
Yes, we could do that. I was hoping to have completed with Mr. Courtney first and then a break. Are you back, Mr. Courtney?
Sorry.
Yes, you
Yes,
went off a
are you
little
hearing
bit.
me?
Yes,
Can I ask Mr. Courtney a very short question, actually? If I could, Mr. Courtney, Mr. Smith points us to 175 and says that that therefore implicates legislation and administrative practices. How do you respond to that? Within Chapter 8.
I'm being told that you're not seeing me.
No, we're seeing you and hearing you. Please proceed.
My apologies again. Again, Your Honor, very attractive, superficially attractive, but one needs to understand what that is addressing. That is saying that a program of activity must be elaborated in order to implement community competition policy. If that program is not complying with the timelines set out in Article 175, an appropriate case may be brought in the original jurisdiction against a particular member state. The remedy for that is not the remedy Mr. Smith wants. I simply say, if it is alleged that Belize has not complied within 24 months and 36 months, and some person who has standing brings a claim to say, court, make Belize comply with Article 175, it cannot result in the Companies Act being struck down. It cannot result in this court saying that a provision in the Companies Act is anti-competitive. I understand the logic of his argument. It is the law that I am looking for.
But is it about striking down necessarily or about a declaration?
The same. The remedy is the same, Your Honor. 175, 174 does not confer, in my respectful submission, any right on the claimants in this case to ask the court to declare the relevant sections of the Companies Act incompatible with 177. It is dealing with a completely different thing. I understand the logic of what is argued, but it's my respectful submission that you cannot rely on this to grant the relief or to provide the advice, I should say, sought in the question.
Thank you. Any final word on this? You have a couple of minutes remaining.
Your Honor, my final point is, and this is really when every argument I have presented has been rubbished, we say finally we rely on section 1, article 177.4, which provides for a public body to do certain things and it creates an exception. And we commend the affidavit of the Director General of the Financial Services Commission, which sets out quite clearly and in extenso the public policy objective of this particular provisions. And so we would say it would fall into the exception if it is purposively construed. Your Honors, unless I can be of any further assistance, indebted.
We are also grateful to you, Mr. Courtney. Shall we take a short break now for 10 minutes and return in 10 minutes' time? Deputy Registrar?
Thank you, President. Court adjourned. Thank you.
Much obliged, Your Honors, if it pleases you. Your Honor, I have heard the representations on behalf of the first respondent, and the second respondent agrees in terms of the interpretation to be adopted to Article 214 and the approach in regards to the court's jurisdiction pursuant to Article 214. However, we diverge to the extent of whether in fact we say that the court in fact has the jurisdiction. And it is a submission of the Attorney General that this court does in fact have the jurisdiction to provide the advice that is being sought in relation to the question that has been posed. Your Honor, when you look at the case that we have provided to the court, this is the DCP successors as in the jurisdiction of Jamaica. Your Honor, based on a conversation had with both my learned seniors, the question that remains for this court, it seems, is the necessity. That is, whether in fact a decision or the advice of this court is in fact necessary for a determination of the issue in the lower court. Your Honor, in our written submissions, we have provided what the court in Jamaica considered to be what is necessary. And this is provided for at our paragraph 7, which is at page 177 of the record. And the court said, whether it is necessary, it means that the import of the other principles surrounding the meaning of necessary to deliver judgment, I believe to be applicable in our jurisdiction. Lord Denning, in the decision itself at page 442, suggested that the appropriate test to determine if the referral of the question is necessary to deliver its judgment is whether or not the answer to the question on the meaning or application of the treaty would result in judgment for one party or the other. Respectfully,
Ms. Matute, if I may come in at this stage, it seems to me that, forgive me, Mr. Courtney, if I'm reformulating your argument, but allow me, it seems to me that the point of that argument Mr. Courtney is making is, look, Article 214 has no time limit on it when a referral may be made. And for us to, if we are going to talk about necessity, we really mean necessity. It may be that necessity is not something you determined at the preliminary stage of a case. It may be that the point to gauge necessity is actually when you are sure, as a first instance court, that you are going to be interpreting the Treaty of Chaguaramas. It may be that that stage would be at the stage when you are actually writing your judgment. And it becomes clear to you that, look, we cannot avoid dealing with the Treaty of Chaguaramas. At that point, the question of necessity arises, and not at the early stages where it looks like it might be something that may go there, but when you get to the point, no, we don't think that question truly arises. Isn't that a way of looking at it?
Respectfully, yes, Your Honor, that is one way of looking at it. However, when you look at the circumstances of the particular case that is before the High Court, it is in fact a mixed claim seeking constitutional relief as well as administrative orders. And when you look at the reliefs that are being sought, yes, there is one that contemplates the unequal or discriminatory treatment of the claimants. However, there is a specific question and a specific relief that the court is being asked to make a determination on, and that is whether in fact the treatment of the claimants are in fact unequal when you contemplate what the RTC contemplates in Article 177. And so, Your Honor, it may very well be that the court could say, well, their issue of constitutional issues do not arise. However, there may be an issue for the determination on the RTC because there is this declaration being sought to make a determination on that. And we say respectfully, Your Honor, that when you look at what is before the court, that it is necessary for this court to provide some guidance, some advice on the interpretation, on the application of Article 177 2D for the court to be able to make a determination on that. I heard my
Ms.
learned senior,
Matthew, just
Mr.
a quick point, please, because I wanted to just pick up on something you just said. Now, you referred to Justice Staples' judgment in DCPS, where he was cross-referencing some dicta of Lord Denning in the Bulmer case. Bulmer, yes, case.
Yes, Bulmer.
That's an English Court of Appeal case where at the appellate level, the decision of the National Court to refer was under review. But what I'm trying to understand is why would the CCJ, in answering the question of whether it has jurisdiction or even whether it ought to exercise the jurisdiction it has, engage in an assessment of the quote-unquote necessity of the referral, because you're cross-referencing the understanding of necessity that both Justice Staple and in Bulmer, Lord Denning engaged in. And in substantiating your point that it's quote unquote necessary for the CCJ to provide the interpretive guidance, it seems to me that what you're assessing is one of the issues we're calling the objective criteria, which is the National Court seized of an issue? You know, I'm looking at Article 214, but is it seized of an issue involving a question concerning the interpretation or application of the treaty?
Yeah.
It is so seized because of what was pleaded. And you've cross-referenced it quite clearly. So I'm just saying, I don't understand how necessity comes into the picture at all for us in determining jurisdiction, as opposed to in the context of maybe an appeal at the domestic level that is seeking to review the decision or the exercise of the discretion of the National Court to make the referral. Could you respond to that, please?
And just to pile on to that, if I may, Ms. Matsuta,
Yes,
again, and this was read earlier, but remember, 214 says in the relevant section, if it considers that a decision is necessary to enable it to deliver judgment. So the it must be referring to the Belizean court. There is no suggestion that the issue of necessity is something for us to consider, at least on that reading of it. All we have to be sure of is that this is an issue whose resolution involves a question of interpretation or application of the treaty. So, like my sister, I'm a little bit puzzled as to why we are looking at this issue of necessity. It's not for us, is it?
Yeah. Much obliged, Your Honor, and I'm grateful for the question. Your Honor, how we have viewed it is that, yes, the court does have the jurisdiction, but there has to be that invocation of this court's jurisdiction from the National Court. And the basis of the invocation of this jurisdiction is where the court is making a determination of its own volition to say that it's necessary that there is an issue before me. It requires the assistance of the Caribbean Court of Justice in its original jurisdiction to make that determination, Your Honor. And so respectfully, we say that when you look at the scope of that necessity, it has to come into play with how it is that the court will then say, okay, I am now being asked to make a determination. When you look at Article 211, it imposes
which court?
Provides
Sorry. Which court?
on this court, Your Honor.
This court? No. Okay, but I just thought that, the concept of necessity had completed its work when the local judge decides to refer the matter. I'm just not sure what further work is there to be done by that word here in the CCJ. But I think I've made a point, sorry. Please, yes.
Your Honor, I hear the court, I hear Your Honor. And so we would go to Article 211, which talks about the exclusive and the compulsory jurisdiction of this court to determine, well, not to determine, but to provide guidance. So in its interpretation, in its application of the provisions of the RTC. And so this is why we would say, Your Honor, respectfully, that where we are now, the court does have the jurisdiction because the court below, the national court, was in fact satisfied that there was an issue that requires some determination as to the interpretation, as to the application of specific provision, Article 177.
Okay.
Your Honor, we also say that it's appropriate at this stage to make that determination that the court does in fact have jurisdiction and will exercise its jurisdiction is because of the stage in which the proceedings are at. A review of the papers before the court, this matter was already set for trial in February. We are now in May, which would suggest that there would have been the pleadings before it to make that determination that there was a question that required the court's interpretation and the court's application. And so, Your Honor, for that position or for that submission as well, we would say that it is imperative on this court to make a determination that it does in fact have the jurisdiction and that it will seek to exercise that jurisdiction.
Very well.
Your Honor, if there are no further questions in respect of the jurisdiction issue, then we would just move on to the substantive question that has been put to the court.
Yes, please. Thank you.
Much obliged, Your Honor. So turning to the substantive issue before this court, which relates to Article 177 2D, we, just like the counsel for the first respondent and as well as the claimants, say that there should be a purposive approach being given to the interpretation to ensure that its application is in fact furthering the objectives of Part 8. And as the court is very much aware, Part 8 establishes this competition regime in the CARICOM market. And so the object of Article 177 is to prevent anti-competitive practices, particularly among enterprises. Your Honor, when you look at Article 177.1, it identifies the forms of conduct captured by the competition regime. And if you look at it specifically, Your Honors, it talks about anti-competitive agreements. It talks about actions that there is an abuse of dominant position in the market. And it also allows for a catch-all for there to be a consideration of any other conduct which the court may deem to be anti-competitive practice. And then, Your Honors, if you go on to Article 177.2, this provides explicit examples, though may not be exhaustive, of what may constitute anti-competitive practices. And if I may, Your Honors, as I said, specifically in relation to our case before you, this has to do with 177.2D. And this talks about the application of unequal conditions to parties undertaking equivalent engagements in commercial transactions, thereby causing a competitive disadvantage. When you look at this specific provision, Your Honors, we say that there are certain considerations that the provision contemplates, including that there, in fact, are unequal commercial conditions, which would, in fact, result to a distortion or a disadvantage on the market. However, Your Honor, there is one qualification in relation to the application of 177, and this is in respect of enterprises. It is limited to the conduct of enterprises. As the court has already been led to, Article 1 provides the definition of what constitutes an enterprise. And simply put, it's saying that you are providing goods and services on the market. And the cases that we have put before the court, Eurocontrol, as well as Hofner and Elser, it doesn't exclude that a public authority may in fact be conducting itself as an enterprise. However, what the courts look at is to see in fact whether the nature of that activity is in fact economic in the sense of providing goods and services on a commercial market. And respectfully, Your Honors, we say that when you look at the functions of the FSC, the first respondent, we say that the functions simply does not meet the threshold to be constituted an economic activity.
Ms. Matut, there are parts of the world, if I may be blunt about it, in the United States, for instance, the occupation of lobbying is a big business. Maybe the same thing in Canada. The point there is you have business enterprises who would lobby legislators to implement certain rules. Often those rules are market protective rules. Are we saying that where that happens, that will not amount to something community and economic community should worry about? Is it enough to say, well, we leave it to, we're going to point the focus lens on enterprises, whereas enterprises may have lobbied government to put in place regulation that, in fact, enables the anti-competition rules to thrive. Should we ignore that in the interpretation of Article 177, or isn't that a concern that Article 177 should worry about?
Your Honor, when I look at Article 177, yes, it talks about enterprises. And as I have submitted that, it also contemplates the inclusion of public authorities in that definition, so long as it's an economic activity. But when you look at the definition of what an economic activity is, it's squarely for the provision of goods and services on the market. It's not about what happens behind the scenes in terms of putting legislation which in effect would enable these anti-competitive practices. And so when you look at the circumstances of this case, that is not the case here, where there is a suggestion that there has been enterprises, even if you don't want to, even if you accept that the FSC is an enterprise, there is not the suggestion here that there has been the encouragement as being suggested. When you look at the functions of the FSC, it's really just regulatory in the sense that it provides a service to the extent of there being records for companies. And in the particular case of the claimants, companies that are not registered in Belize, it in no way suggests that there is a distortion in the market. It does not suggest that they are not able to engage in the market at a competitive level. So we would say respectfully that when you look at the circumstances of this case, that is not the case here.
Thank you.
Your Honor, I don't know if I have answered your question.
Please proceed. You've done the best you can.
So to complete my argument in terms of the enterprise, Your Honor, respectfully, we'd go over what it is that we view the exercise of the FSC to say. We say that when you look at the powers which is under challenge, they are statutory and regulatory in nature, relating specifically to corporate supervision, regulatory compliance, maintenance of corporate records, and the general administration of the Companies Act. And we respectfully say that when you look at these are general public authority functions. It doesn't in any way suggest that it encourages one over the other to have a more competitive edge or that there is a distortion on the market. We also say that the measures are regulatory, not commercial. The challenge requirements, we say again, are administrative and regulatory. The requirement concerning the registered agent, the filing procedures, and the payment modalities govern how it is that the companies interface with the company's registry and not how it interfaces with any other competitor on the market. We also respectfully say that there is no competitive disadvantage that has been demonstrated on this case. So even if it is that you assume that there has been a differential treatment because of domestic companies as opposed to those in the region, Article 177.2 places a burden that there must be proof, that there is in fact a resulting competitive disadvantage. And we say that based on the pleadings that have been put before the court, the claimants have not demonstrated that the impugned conduct of the FSC in fact distorts the competition. And we look at the case of United Brands, in which it was clearly a difference in treatment because of the pricings among the different member states of that region.
Ms. Matthew, you say that the difficulty has arisen because of a difference in treatment between, is it the foreign shareholders and directors and Belizean shareholders and directors?
So there is a different process, as I understand it. And what has been under challenge is to say that there is the fact that there has to be a registered agent for which the CARICOM companies would be able to establish and regulate themselves in Belize.
I see.
So there is the registered agent, there is the filing through the registered agent, and there is the payment of the fees in US dollars.
But are the claimants CARICOM companies in that sense, or are they all Belizean companies?
They are CARICOM because they have been established in CARICOM jurisdiction.
Sorry?
Sorry, Your Honor?
Were they not established in Belize?
They have been registered in Belize through a registered agent,
I see. Yes.
but originally their original jurisdiction is not in Belize.
So there's a reference to, is it foreign shareholders and directors?
Yes.
So it's where the company has those persons. Yes, that there must be these additional requirements. But the definition of foreign shareholders, foreign directors, does that not include CARICOM persons?
One moment, Your Honor. So for foreign director, it talks about meaning a director that is not of Belizean nationality or a CARICOM national. And foreign shareholder means a shareholder that is not of Belizean nationality or a CARICOM national.
So there's no distinction then between the treatment of shareholders, directors who are Belizean and who are of other CARICOM nationality then, is there?
No, respectfully, based on the definition, there should be no.
Right. So it's perhaps a good thing we're not inquiring into the necessity issue. That's a matter to be resolved by the local judge, right? Okay. Further submissions, ma'am?
Yes, please, Your Honor. Just one final point that we would like to put forward to the court for its consideration in making its determination is to look at the objectives and whether in fact the objectives of the FSC falls outside the scope of Article 177. And we ask the court to look at the case of Werthers, where the court recognized that the measures pursuing legitimate regulatory objectives do not fall afoul of the competition provisions merely because they may affect market conditions. And when it is that the court is looking at the regulations, the court is invited to look at the extent of the considerations in the specific provisions and whether in fact they serve a legitimate objective. And if they in fact do serve a legitimate objective, whether in fact they are so restrictive. And so we say again, when you look at the scope, when you look at the functions of the FSC, it's really just a regulatory body. It provides support to companies, it provides data to companies, and it also provides that there is compliance under the Companies Act.
Yes. When you say just a regulatory body, of course, we're not trying to downgrade the importance of regulatory bodies.
Yes. Of course, Your Honor, it's very important, at least based on what has been put forward to the court in terms of the scope and the extent of the assistance that is provided by the registry. In the affidavit of Mr. Burrell, he says that they provide critical assistance to the courts, and they also provide critical assistance to the public at large as it relates to these companies, Your Honor. So it's really to provide that information.
Excellent.
Much obliged, Your Honor.
Thank you very much, ma'am. Okay, so
if I may, please, President.
Please, yes, sir.
Yeah, Ms. Matut, I was with you all along when you were making your submissions on enterprise and stressing that, you know, the way it was defined having to do with goods and providing goods and services and this question of economic activity. But then I lost you for a bit where I think you were making a submission that quite apart from that, the evidence in this case doesn't suggest, and please correct me if I misunderstood you, but I think you were saying something along the lines that the evidence in this case didn't suggest that what the FSC is doing is distorting the you know, or creating any kind of anti-competitive conduct in the market with relation to its regulatory practices. I'm not sure if I misunderstood you, but are you saying, therefore, that if there was evidence of this nature, that notwithstanding your submissions around the meaning of enterprise, that perhaps then a non-for-profit or one of those kinds of entities could come within or could be captured by Article 177?
Your Honor, what I'm saying is that once it is that the entity, and very well, it could be a nonprofit, once you are engaging in economic activity, so that is providing goods and service on a commercial market, and there is that competition with rivals or with competitors in respect of that market, then the activity, yes, would constitute an economic activity, and then yes, the entity would be considered an enterprise for the purposes of 177.
But you're excluding regulatory activities from this?
In the sense of this particular case, yes, we are respectfully asking that when you look at the regulations in this particular case, that it does not constitute an economic activity in the sense that has been defined and prescribed by the cases.
Okay.
Thank you, Ms. Matut. So we come now to our amicus, Ms. Rodolfo. Thank you for staying up in the United Kingdom where you are now. And we have agreed that we'll hear you for 10 minutes.
Thank you, Your Honor. May it please the court, the amicus appears today pursuant to the order of this honorable court on the 14th of May, 2026. And we confirm that we have and continue to maintain impartiality and independence throughout these proceedings. In order to be of assistance to the court, the amicus will limit its submissions today primarily to the interpretation of Article 177 of the Revised Treaty of Chaguaramas. And the amicus respectfully submits that regarding the referred question, Article 177 is not the provision under which the claimant grievance is to be assessed, because Article 177 concerns anti-competitive business conduct by enterprises, and the conduct complained of on the facts is legislative and administrative conduct of the Belizean state. To this end, and without being repetitive of the submissions already made by my learned friends, the amicus advances 4 main points. Firstly, that the doctrinal anchor of Article 177 is the concept of an enterprise, and the CARICOM analog to that is the concept of the EU analog to that is the concept of an undertaking, and the Financial Services Commission and the Belizean legislature do not fall within that on the facts. Secondly, the grievance does properly fall within a comparable body of authority concerning restrictions as it relates to cross-border company formalities, more properly dealt with under the freedom of establishment as EU case law has established. Third, the formulation of the referred question aligning to subsection 2 part D mimics the language of the Mio case, but in these circumstances, it's doctrinally misplaced in terms of what the claimant is attempting to do with that language, as well as it does not properly consider theories of economic discrimination and what that requires. And then lastly, for this court, address the systematic reasons as to why competition law regimes are kept separate in their operation from non-discrimination and freedom of movement regimes, and why that should apply in the CARICOM context. Now, as it turns to the concept of enterprise, I will not further enumerate the court with what has already been discussed. What I will do is point to the 2 authorities which I sent to my learned colleagues this morning, but did not file, so I beg the court's indulgence in this regard. But in order to be useful, I did pinpoint the specific paragraphs that...
Mr. President, while I did not object to Mr. Courtney's single law authority sent yesterday, because I had the overnight to look it over, I most definitely object to waking up, coming to my office and finding 3 new authorities, which I did not have time to review. So I certainly think that is very unfair for the amicus to attempt to rely on them, and I object to any reliance being placed on them.
Thank you, sir. I think in the circumstances, Ms. Rodolfo, we should proceed without such reliance. Thank you.
No problem, Your Honor. It was simply to reemphasize the point that where there is regulatory or administrative action by a particular public body, it is considered to be an exclusion within the framework of competition law. And in applying that to the FSC, what the provisions fall under that are being challenged are norm setting and administrative implementation. They're not offering services on a market in any sense, and that's recognized by competition jurisprudence as not being under the scope. And even conduct such as the collecting of fees are also considered to be administrative, which is analogous to the fact scenario here. Now, moving to the second point as it concerns the claimant's grievance. Within the fact pattern, what we are seeing is regulatory burdens being imposed by having additional requirements for certain nationalities being company incorporations. And the treaty, the lines of cases have shown that this has been better interpreted under freedom of establishment provisions as opposed to competition provisions. As we have accepted Mr. Smith's objection, I will not get into the particular case on this fact. But why that would matter for Articles 177 interpretation, it's because the natural and correct legal characterization of the measure falls within those provisions and not competitions. And if you look at it, it's more analogous to that particular subsection of the treaty, because competition primarily relates to markets, enterprises, and trading partners. In the circumstances on this case, we have none of the above being recognized. What I will address and what has come up in questioning is the instances where states, through their actions, may have I don't want to say implement anti-competitive outcomes, but in terms of the jurisprudence, when states have been involved in competition matters, and these are authorities that have been relied on by the claimant, which is Van Eyck, 1998, which has the legal test established. There are specific criteria that they would look for before they invoke state involvement to say the state has been anti-competitive in any way. So those three things are the measures that the state would implement would either one, require or encourage private undertakings to engage in anti-competitive conduct, or two, they reinforce the effects of such anti-competitive agreements, or three, it would deprive the own legislation of its sovereign character, delegating to private traders the responsibility for taking decisions affecting the economic sphere. Now, if we look at those three criteria against the provisions that are being challenged, there's no application on the facts. So it is on this basis that we say that trying to extend the competition regime to state implemented legislation is inapplicable in the context. Moving on to the framing of the question and the language being invoked, I place reliance on the case of Mew, which is also referenced by the claimant. And this is the framing of the question specifically when it comes to unequal conditions to equivalent transactions causing competitive disadvantage. Now, if we look at that case that is being borrowed doctrinally, that case concerned Article 102, subsection 2, Part C, which focuses on dominant undertakings in a relevant product and geographic markets. And here we have no dominant undertaking, as we've already established that the FSC is not an undertaking to begin with. There's no relevant market being pleaded on the facts. There are no market shares to show that the FSC, even if it were in the market, is operating in some way to have a dominant position. And the threshold is simply not engaged. And then the second part of that is that the dominant undertaking is applying dissimilar conditions to its trading partners. Here again, as we say, the FSC is not engaging in the market in any way, so there are no trading partners. And then lastly, if we look at the mismatch on the facts, again, there's no dissimilar conditions because the case itself involved a Portuguese collecting society that was doing different royalty tariffs, but it was also operating within the market itself. So given that there's no integration of upstream or downstream markets, or even a market to begin with, as I already said, it's inapplicable on the circumstances on the facts. Now, if we
also, I know you have limited time. Can I just, you said something a lot earlier on that basically the complaint under Article 177 was misplaced or inapt. And you said the complaint is better placed under the right of establishment. What did you mean by that?
I would like to get into it, but Mr. Godfrey has objected to the particular fact. But what I simply meant by it is that, if I could just give me a moment to find my notes. Right. What I meant by that in particular is that where we have situations where, let's say, a CARICOM member is being subjected to additional requirements that are not equivalent on a domestic level within the country which they seek to operate. These can be restrictions on establishment if there's no justified overground for public interest as to why this is being done, because it essentially is creating a barrier to market access or the operation of the market from the regulatory standpoint, not necessarily a competition standpoint, but it's an additional burden to.
And you would say that I think your point is that could be one way in which the state action or measures could have been reviewed. But I think your point is, if I understand you, is that's not the challenge that was brought in this matter. Yeah, all right.
Yes.
Okay, thank you.
Okay, and then moving along to the economic mismatch, where it comes to the economic theory. The economic theory underpinning prohibition of price discrimination and competition law assumes there's a dominant supplier exploiting market power against trading parties who, again, compete with each other on a downstream market. The harm is the distortion of the downstream competition caused by an upstream firm, and none of that is present in the case. As much as you may be able to distinguish the facts, there's no anti-competitive engagement because there's no conduct to begin with. So this is why trying to engage this section is not appropriate on the facts. And then lastly, in terms of why we keep competition and non-discrimination separate, and I particularly slightly engage with this in paragraphs 27 and 28 of the amicus brief. But simply put, competition law and non-discrimination address different legal wrongs and apply different operative legal tests. Competition law targets market rivalry caused by the conduct of enterprises, and that typically is two things, either collusion, as captured under Article 177, subsection 1, and abuse of dominance under Article 177, subsection 2. So we focus on market power and coordination between rivals. So we focus on a few main factors, which is there enterprise? Is there market power or coordination? Is there an effect on competition, and is that effect appreciable? When it comes to non-discrimination and even free movement by extension, the focus is on differential treatment by states, and that restricts market access and equal participation. So there, the test more focuses on differential treatment and whether that treatment is direct or indirect, if there's an origin nexus or nationality, and if the measure can be justified. So in that sense, if competition law is overextended into state regulatory measures, which is what the claimant is asking here, regulatory measures that have commercial effects, the boundary between competition-like wrongs and regulatory wrongs becomes very difficult to decipher. And what we will have is a situation where we produce double review, inconsistent standards, and there would be no legal certainty in the construct. So in that sense, I would advocate and submit against the extension in this regard, as well as the fact of we also have to consider the institutions under the RTC, which I don't think was ventilated in the proceedings today. The CARICOM Competition Commission established under the treaty is instituted.
Ms. Rodolfo, I'm sorry, but I do think that your time has expired.
That's my time.
Yes. We have
No
your
problem.
written submissions, and of course, we will look at them and consider them carefully. I want to thank you very much once again for providing the court with your submissions. Thank you, ma'am. Thank you very much.
Much obliged, Your Honor. Thank you.
Very welcome. We are now going to hear the responses from, first of all, the second respondent, if there is such, Ms. Matut.
Your Honor, the extent of any response would be in relation to the discussions in reference to the right of establishment. Your Honor, respectfully, we ask the court to just limit its consideration to the specific question that has been raised, which is in reference to Article 177 under the RTC. Respectfully, Your Honors.
Thank you very much. Mr. Courtney?
May it please the court, my learned friend took my words. I also urge the court to confine itself to the question that has been referred, and I appreciate why the amicus mentioned the matter, but I suspect that that is wider than what has been referred to the court, and I urge the court very strongly not to get into it, not only because it's not been referred, but also because we have made no submissions on it. Yeah. Deeply obliged, man.
Thank you, sir. Mr. Smith.
A few short points in reply, Your Honors. First, in relation to my friend Mr. Courtney's vigorous objection or protestation, I should say, to referring to articles of the revised treaty not included in the reference or not pleaded. My recollection, Mr. President, is after this court at the case management conference had reformulated or narrowed the question, Mr. Courtney specifically asked of the president whether we were limited to that particular article or whether reference could be made to other articles of the RTC. And the response from yourself, Mr. President, was yes. I will say no more on that, save that it can easily be checked with the records, from the records of that case management conference. The second point I wish to make is that while I agree with President Anderson's view of the necessity test as advocated for by the first respondent, I simply say that even on that test, the claimants would satisfy the 5 requirements, the five prong test. The only questionable one would have been whether the breadth of the question, and that in any event was narrowed by this court. And we in response to that narrowing of the question, confined ourselves to that in these submissions.
Mr. Smith, allow me, there's something that came up from the president's inquiry, a line of inquiry with Ms. Matute here that I thought I need to hear you on. The premise of your complaint is that there are certain provisions in the Belize Company Act that impose burdens upon CARICOM nationals seeking to operate in Belize. Burdens on the basis that those CARICOM nationals are presumably foreigners.
Right.
Then, and in that exchange between the President and Ms. Matute, it seems that CARICOM nationals are not considered foreigners for purposes of those provisions in the Company Act. What are we to make of that?
All right, so
in the context of this referral?
Right, so first of all, to clarify the situation, it is true that Belize registered companies with CARICOM directors or shareholders on the letter of the Belize Companies Act are exempt. What the documents placed before this court show is that the FSC, in its application of the law, still requires those companies with CARICOM shareholders and directors to abide by the requirements. In addition, companies that are CARICOM incorporated are also required to abide by the company law requirements. So the complaint is on 2 limbs.
Mr. Smith, just to confirm, this seems to be underscored in the factual background of the question referred to the court, where there is reference to the requirements as applied.
Yes.
Thanks.
Yes. Yes.
But if the application, Mr. Smith, is not consistent with the law, is the remedy not staring us in the face?
Well, but remember there are 2 limbs, as I just said to Justice Ibo Usuji, that there are also, it also applies to to CARICOM incorporated companies. So it applies, the requirements imposed by the FSC applies at 2 levels. CARICOM incorporated companies, and although it shouldn't apply on the letter of the law to Belize registered companies with CARICOM shareholders or directors, in practice, in its application, the FSC imposes the requirements on them as well. So that's
Mr. Smith, is that a question of interpretation or application?
One is interpretation, meaning the purely CARICOM incorporated companies. The one in relation to Belize.
No, sorry. So is it that the statute only speaks to shareholders and directors, but not CARICOM incorporated companies. Is that what you're saying?
It does not allow CARICOM incorporated companies the same exemption from the requirements as Belize registered companies.
Okay, fine. Yeah.
On that note, again, to inquire if maybe it should have been part of the main frame of the debate, quite apart from the requirement of paying fees, applicable fees in US dollars, is it for really that inconsistent with the Revised Treaty of Chaguaramas to say, well, we need to have those who operate within our jurisdiction to have a presence in our jurisdiction for purposes of regulation, for purposes of implementation of the rules, because Belizean nationals are already here, so we can have direct operation, we can have direct enforcement on Belizean nationals who are here. But we need to have foreigners who want to operate, even if they're CARICOM nationals, to also have presence within our jurisdiction so that we can implement the rules against them. Is that really inconsistent with the RTCE?
I think if my understanding of referral powers is correct, I think that that's a secondary interrogation is for the High Court of Belize. Once this court determines that, yes, it appears to us that the regulations are capable of being covered by Article 177.2, read with all the other provisions of the treaty, then that second limb is engaged, and there has to be an exercise of determining whether the so-called gatekeeping functions of the requirements as it's characterized in the affidavit of Mr. Haylock, whether in fact those fit into the exemptions under Article 1774, and whether they are proportionate. I don't think that at this juncture the court is engaged on that exercise. Two more points. My learned friend, Mr. Courtney, characterized our submissions as an attempt to turn upside down all the understandings in relation to the jurisprudence surrounding Chapter 8. That is, of course, not the case. We have attempted to nuance our submission to recognize what the primary focus is, but we go on to say that because of the existence of provisions like 175, actually implicates the regulations, and so it should not be interpreted in a narrow, confined way. I won't repeat myself on that. Again, the point was made that Section 175, which we rely on, does not confer any right to declare relevant sections of the Belize Companies Act as compatible with Article 177. I believe that was a contention of the first respondent. But again, we're not advocating, we're not saying that 175 confers a right. We are saying that 177.2d needs to be read with other extremely relevant, pertinent provisions. When those are read together, all that it doesn't give any right to declare anything. All that it does is that it provides a fulsome interpretation of what 177.2d is directed at and how it ought to be interpreted. Finally, we would just wish to point out that Chapter 8 is termed competition policy and consumer protection, and within that are the rules. In interpreting Chapter 8, Chapter 8 is not limited to the strict technical competition rules. It also is introduced by and contextualized by broader policy principles at 168, 169, and 175, which we rely on, so that it's not a matter of unjustifiably extending, it's a matter of reading 177(2)(d) in its proper context of competition policy. And I believe, and 168 as well, Your Honors, the rules of competition shall not apply to, and it lists A through E of the things that the rules of competition do not apply to. And it does not, not listed in that list is regulatory measures and arrangements. We say that provides some comfort, some support to the broader view being advocated for. And we say that indicates why the section under review ought to be interpreted with the broader principles, the whole context of chapter. And that would be the extent of our response, our reply. Mr. President, thank you for your attention, and justices.
Thank you, sir. So we want to thank again Mr. Smith, Mr. Courtney, Ms. Matute, and Ms. Rudolfo for your assistance in this matter. Naturally, we're all parties to this historic event, our first referral, and we're very grateful for the help that you have provided for us. We will notify the parties in the main proceedings and our amicus as to when it is that we will have the interpretation available for the High Court. And of course, we will provide that interpretation in due course. We are, as you would appreciate, seeking to make sure we do not disrupt the main proceedings for too long. And therefore, we intend to be very expeditious in the provision of the assistance requested. Thank you all once again. Madam Deputy Registrar, would you please close the proceedings?
Thank you, President Anderson. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Monroe. Thank you, Mr. Justice Ebul Suji. And thank you, Mr. Justice Balkan. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.